Hello everyone, welcome to another session of Lucid Mains. Today, we will look at the topic of reservations in India. As you may already know, this topic is very important for your GS2 preparations as well as for those attending the interview this time. So, let us begin by looking into the recent news about reservation. The most important news in the 103rd Constitutional Amendment Act. Recently, President Ramnath Kovind gave assent to the 124th Constitutional Amendment Bill, making it the 103rd Constitutional Amendment Act. This act seeks to provide 10% reservations for economically weaker sections in the matters of education and public employment by creating a new category called Economically Weaker Section or EWS. Prior to this, in Maharashtra, the government announced a 16% reservation for Maratha community by creating a new category called Socially and Economically Backward Classes or SEBC. Before we move into the details of the new act, let us take a look at the various constitutional provisions that facilitate reservations in India. When our constitution was framed, the makers of the constitution created special provisions with the intention to provide equal opportunity to all the citizens of India. Such provisions can be found in various parts of the constitution, but the core lies in two articles, namely Article 15 and Article 16. Under Article 15, Clause 3 empowers the state to make special provisions for women and children. Similarly, Clause 4 empowers the state to make special provisions for advancement of socially and educationally backward classes. Besides this, Clause 5 empowers the state to make reservations in admissions into educational institutions, including private institutions, except for minority educational institutions. Now, under Article 16, Clause 4 empowers the state to make a special provision for those backward classes who, in the opinion of the state, are not adequately represented in the service under the state. Also, Clause 16 4A empowers the state to make reservations in promotions for SCs, ST and OBCs. Besides these provisions, the most notable is Article 335. Now, 335 states that the claims of the members of scheduled caste and scheduled tribe shall be taken into consideration in making the appointments to services and posts in connection with the affairs of the union or of a state. Now, moving on, let us look into the history of reservation in India. Since the inception of our constitution, reservations and special protection for the scheduled caste and scheduled tribes are being provided. A drastic change in this setup came when in 1972 the Union government formed the second Backward Classes Commission under B.P. Mundell, a former member of parliament. Its primary assignments included determining criteria for defining India's socially and educationally backward classes, recommend steps to be taken for the advancement of those classes, and to examine the desirability of reserving state and central government jobs for those classes. After 2 years, in 1980, the Commission submitted its report to the President, in which it developed 11 categories of social, educational, and economic backwardness. Also, the Commission generated an OBC list after conducting demographic surveys across different districts in the country. Based on these, the Commission recommended 27% reservation to the backward classes in case of public employment as well as in promotions. It also recommended for providing age relaxation to the backward classes. Later on, in 1990, the V.P. Singh-led Union government announced that they would implement the recommendations of the Commission along with reservation of 10% government jobs for economically backward classes among the higher caste. However, this move was challenged in the landmark Indira Sawhney vs. Union of India case, which is popularly called the Mundell Case. Now, in its judgment, the 9-judge bench of the Supreme Court upheld the Mundell Commission's 27% quota reservation for backward classes, as well as the principle that the combined scheduled caste, scheduled tribe and backward classes beneficiaries should not exceed 50% of India's population. But the court was of the view that economic criteria cannot be the sole basis for determining the backwardness of citizen. So, the court struck down the 10% reservation in government jobs for economically backward classes among the higher caste. It also introduced the concept of creamy layer. The court ruled that those in the backward classes who belong to the creamy layer be excluded from enjoying the reservation facilities. But in the years following the Indira Sawhney judgment, the government made four major amendments to the constitutions, namely the 77th, 81st, 82nd, and 85th. In a sense, they diluted the judgment by providing not only for reservations in promotions but also for consequential seniority on that basis. These amendments were then challenged in the M. Nagaraj versus Union of India case. In this case, though the court upheld the constitutional validity of the amendments, it put forth some guidelines to be followed while granting reservations. The court ruled that if the state wishes to make a provision for reservations, it has to collect quantifiable data showing backwardness of the class and inadequacy of representation of that class in public employment. It also directed that such an action be done in such a way that the overall administrative efficiency is not detrimentally affected. Also, the court made it clear that even if the state has a compelling reason, it has to make sure that its reservation provision does not breach the ceiling limit of 50% or obliterate the creamy layer. Now, let us look at the provisions of the new Act. The Act has amended Article 15 of the Constitution by adding a clause 15(6), which enables the state to make special provisions for advancement of any economically weaker sections of its citizens, including reservations in private educational institutions. It also amended Article 16 by inserting a new clause 16(6), which enables the state to make provisions for reservations in appointments in addition to the existing reservations, subject to a maximum of 10%. It is stated that the Amendment Act aims to fulfill the commitments under Article 46. This article, which belongs to the DPSP part, asks the state to take measures which seeks to promote the educational and economic interests of the weaker sections of the society. As per the Act, general category individuals whose family together earns less than Rs 8 lakh per annum and who have less than 5 acres of agricultural land are eligible for the 10% reservation. Now, let us take a look at the benefits of the 103rd Constitutional Amendment Act. First of all, the move is expected to benefit around 55 million households in the country. Also, though unintentional, the Act will help remove the stigma of reservation itself. This is because historically, the reservation has been associated with caste. By including upper caste under the sign of reservation, it dissociates caste and the stigma of reservation. Besides these, this Act, if successful in its implementation, has the potential to force a review of earlier reservation bills that are not based on economic criteria. Also, it will help ease the tensions and agitations demanding reservations that have long been going around in states such as Gujarat, Maharashtra, and Rajasthan. Now, let us look at the various concerns created by the Act. Firstly, it is not clear if the proposed reservation will apply vertically or horizontally. Now, vertical reservations are like the reservations for scheduled castes and scheduled tribes. They are for a particular category and cannot be demanded by those outside this. But horizontal reservations are applicable to a wider range, like for instance reservations to women or disabled people. Now here, if the bill is vertical, the policy would breach the 50% cap on reservation espoused by the Supreme Court in the Indira Sawhney case. Also, running the policy vertically would jeopardize the right to equality under Article 14, as an SC or an SC or an OBC poor would be restricted from claiming reservations under the EWS quota despite being economically disadvantaged and socio-economically backward. The next concern is that the Act seems to violate the basic structure doctrine of the Constitution. The 9-judge bench in Indira Sawhney case had ruled that reservation is a remedy for historical discriminations and its continuing ill effects, and it is not aimed at the economic upliftment or poverty alleviation. But by introducing economic criteria through amendments in Article 15 and 16, the legislation has done exactly this. Such an amendment could lead to the virtual deletion of Articles 15.4 and 16.4 from the Constitution. Since these articles form a crucial part of the basic structure doctrine, questions remain whether amendments to these will pass the test of the court. Next is the fact that the policy bypasses the constitutional qualifiers for reservation. In the Nagaraj verdict, the apex court has said that the reservation solely on the basis of economic backwardness, that is, without evidence of historical discrimination, finds no justification in the constitution. But the amendment makes a departure by extending reservations to the economically disadvantaged. While backwardness has been ostensibly addressed by the insertion of Article 16(6), the government has provided no data to substantiate the inadequacy of representation. Also, by seeking to open up the reservation policy on an economic basis, the government can be accused of using what was meant to be a measure of social justice as an anti-poverty measure. The reservation system was never meant to eradicate poverty, it was meant to eradicate social inequality. Thus, this act undermines the fundamental idea behind reservation. The move has also indirectly exposed the government's failure in generating sufficient number of quality jobs. This is evident from the fact that between 1990-91 and 2011-12, the public sector jobs actually decreased by 7%, though our population increased by 30%. The next concern is that the Act violates certain fundamental rights. Take for instance, the Rs 8 lakh an annum threshold proposed in the present bill. Based on income tax data and NSSO report data, this limit makes as many as 95% of the Indians eligible for the new quota. Net effect would be that it constitutionally equates a rural BPL family with a semi-urban middle class family which earns say Rs 66,000 per month. This directly questions the principle behind right to equality. Also, creating reservations at private unaided educational institutions would encroach on the freedom under Article 19(1)(g), which grants the freedom of profession. Another concern is the reduction of opportunities for the other backward classes. Till now, the OBCs have been free to compete with others in the general category comprising of 50.5%, which is not reserved. But the bill seeks to exclude SCs, STs and OBCs from this 10% reservation. So, the competitive pool of the OBCs could come down from about 77.5% to 67.5%. This also leaves the question on whether or not the Act breaches the 50% limit set by the court. Besides these major concerns, some of the minor concerns are that no survey have been conducted nor is any scientific data made available on the backwardness of upper caste. Also, the Act will create complications with multiple requirements of documents. So, let us move on to the conclusion part. The first thing that needs to be seen regarding the Act is whether or not it will stand the test of judicial scrutiny. An NGO, Youth for Equality, has already moved a petition questioning the validity of the Act. But one must realize that the root cause of rising demand for reservations is the problem of worsening quality of jobs and informalization of the existing workforce. Here, rather than reservations, a better option would have been to provide good quality free higher education to those who are unable to access it and creating an enabling environment for better quality jobs in the economy. Besides these measures, there is a need to rationalize the present quota system instead of expanding them further. However, this doesn't mean that we have to change the very essence of reservations and make them about poverty alleviation. Even if the central government wants to give quota to the poor, it should first identify caste in upper caste that are socially disadvantaged and then consider economic backwardness. Now, for the existing reservation structure, several alterations can be brought forth. In case of scheduled caste and scheduled tribe reservations, the Supreme Court has already directed the government to introduce creamy layer system. Hence, here the government needs to take proactive measures to ensure that this directive is made a reality. As for the OBCs, subcategorization can be done across the country like it was implemented in Bihar. This can ensure that the well-off categories in the OBC do not take disproportionate advantage of the OBC reservation. However, all and any of these moves require strong political will among the national as well as the regional parties. Above all, one must realize that only through inclusive development can the clamor for reservation be subdued forever.